I'm Mr. Droste, and today we are talking about Marbury versus Madison, an 1803 Supreme Court case that has often been called the most significant case in constitutional law. One of the reasons that this case is so important is it establishes judicial review, which means the U.S. Constitution is the supreme law of the land. And knowing that the court system can take laws passed by Congress, rule them unconstitutional, and essentially wipe out the laws. Let's get to it. So Marbury versus Madison essentially comes out of the election of 1800. I've discussed the election of 1800 in another video. You can find the link to that video in the description or at the end of this video. But the election of 1800 is often called the Revolution of 1800 because it was a massive change in American politics where you had the Federalists, a political party that was at that time headed up by President John Adams, wiped out of power. Thomas Jefferson and his Democratic Republican allies won the presidency. They also won control of the U.S. Senate and the House of Representatives. So on the way out of power, the Federalist Party took some action that the Democratic Republicans took issue with. Number one, in the early days of 1801, kind of that lame duck period when Jefferson's been elected, but he's waiting to take office in March, the Federalists passed the Judiciary Act of 1801. And this was something that they had been wanting to do for a while, but there was other issues at hand, notably the quasi-war with France during the Adams presidency. And so they didn't get it done during his brief 4 years in office. But what they wanted to do was reorganize the court system beneath the Supreme Court, as well as the Supreme Court itself. They were actually going to reduce the amount of Supreme Court justices from 6 at that time down to 5. But they also wanted to create some new courts so that the current Supreme Court justices would no longer have to, quote, ride circuit, which means sit on lower level courts. So they passed the Judiciary Act of 1801. And in doing so, they created several new judge positions, circuit court judges and justices of the peace. So what happens is 2 days before Thomas Jefferson takes office on March 4th, 1801, President John Adams nominates numerous people to these circuit court judge positions and justices of the peace positions. The next day, 1 day before Thomas Jefferson takes office, the Federalist-controlled U.S. Senate confirms all of those nominees en masse. And then till late in the evening, that night, that being the night before Jefferson takes office, John Adams was supposedly furiously signing all of these commissions so that all these judges he got approved could take office. But they don't officially take office until those commissions are delivered to the nominees. Keep that in mind. So Adams is giving out these signed commissions to his Secretary of State, John Marshall, a name that you should keep in mind as well, because John Marshall was also the Chief Justice of the Supreme Court, nominated early in 1801, just a couple months before Adams left office, to be the Chief Justice of the Supreme Court. So John Marshall delivering these commissions, but not all of them got delivered before Adams left office, and that's where the controversy is going to lie. So one of the people who did not get their commission was a guy whose name was William Marbury. He had been nominated to be a Justice of the Peace in Washington, D.C., and that position actually was not created by the Judiciary Act of 1801, but he still didn't receive his commission. So in comes new president, Thomas Jefferson. Jefferson makes James Madison his Secretary of State. And Thomas Jefferson ordered Secretary of State James Madison to not deliver those commissions the Adams administration had failed to deliver before he left office on the so-called midnight judges. Marbury, one of those people that didn't get his commission, was very upset. He thought he was entitled to that commission. And so when he wasn't going to get the commission, when Thomas Jefferson had ordered Secretary of State Madison not to deliver the commissions, William Marbury brought his case to the U.S. Supreme Court. He wants this case decided by the highest court in the land. He wants his commission. Interestingly, William Marbury filed for that case in 1801, but it was not heard until 1803. And the reason for that is because to get back at President John Adams and his Federalists and their midnight judges, Thomas Jefferson and the Democratic Republicans passed a bill which actually canceled the entire 1802 Supreme Court session. So Marbury files to have his case heard by the Supreme Court in 1801. It's not heard until 1803. So what happens? The case is heard in 1803 in front of the U.S. Supreme Court, and the aforementioned Chief Justice of the Supreme Court, the former Secretary of State, John Marshall. And the court hears the case, and the ruling is what sometimes confuses people, but very influential, continues to influence us to this day. So the court says William Marbury is entitled to commission as a justice of the peace. Essentially, William Marbury was asking for the court to issue what is called a writ of mandamus. And a writ of mandamus is like a court order where the court says you must deliver the commission. However, before William Marbury can get too excited, the court says the Judiciary Act of 1789, which was what was being used to argue for the delivery of the commission, which Marbury's side was saying, look, the Judiciary Act of 1789 says that I'm entitled to the commission and that the court can mandate that with the writ of mandamus. Marshall's Supreme Court and John Marshall himself say that the Supreme Court has no legality to rule on this matter. It does not have the jurisdiction to order that the Justice of the Peace Commission be delivered. So in effect, what happens is the Judiciary Act of 1789 is declared unconstitutional and the law is wiped out. This is what is called judicial review. Judicial review is the court system effectively wiping out a law by declaring it as unconstitutional. They were arguing that nowhere does the U.S. Constitution give the Supreme Court the power to issue the writ of mandamus. So Marbury v. Madison establishes judicial review and the fact that the Constitution, the U.S. Constitution, is the supreme law of the land in the United States. So this would influence us for decades, hundreds of years, right up until now. It is possible for the Supreme Court to wipe out a law that it deems unconstitutional, just like it did here with the Judiciary Act of 1789. So that is Marbury versus Madison. If you like this video, if you learned something, make sure to click subscribe on the channel for more great history videos. We'll see you next time.